for protection and because of the lockdown incident, and that you had been followed over the weekend and were scared of being jumped outside school. You also told him that you had been threatened by an associate of boy X. When paramedics arrived, less than 10 minutes after you had stabbed him, Harvey was not breathing and had no pulse. A large volume of blood was found in his chest. Notwithstanding the valiant efforts of the paramedics and air ambulance crew over the next hour, it was not possible to save his life. By the time of the tragic events which I have described, you had had a long-standing interest in weapons. Found on your telephone by the police were photographs of you posing with a variety of them, including other hunting-style knives, a machete, and a hammer, the earliest of which dating back to April 2024. Your internet search history revealed that, since at least September 2024, you had been using search terms such as zombie killer knife, dagger, pocket knife, and machete. In December 2024, your mother had contacted the school, having found an axe in your bag. When a police officer visited you at home on the 27th of December, you told him, untruthfully, that you knew nothing about it. He advised you about the dangers of carrying weapons, advice which you ignored. Prior to the 3rd of February 2025, there had been at least one other occasion on which you had been in possession of a weapon, a knife, on school premises, captured in a video clip and in photographs. Notwithstanding all of this, throughout your trial, you sought to minimize the extent of your interest and gave explanations for the way in which photographs of weapons had come to be on your phone, which were, put simply, not believable. Over the period spanning November 2024 and January 2025, there had been 3 separate incidents in which you had become angry and aggressive towards a person and or property at school, including on the day of lockdown. Other records indicate your long-standing inability to manage your anger. I am now going to explain the sentences which you will receive for your crimes. In doing so, I have to set out the information and material which I have considered and the legal principles which I must apply. I shall try to make that explanation as straightforward as I can. Shortly after this hearing, you will have the opportunity to speak to your barristers, who will help you to understand anything about which you are unclear. You will also be able to read my sentencing remarks in your own time. I have given very careful consideration to the pre-sentence report which has been prepared by the Youth Justice team, to the separate statement which that team has provided, to the helpful and detailed written notes on sentence and oral submissions received from the prosecution and the defence, and to the material to which they have referred. The sentence for murder is fixed by law. The law treats children and young people differently from adults. You were under the age of 18 at the time of your offending. Under Section 259 of the Sentencing Act 2020, to which I shall refer as the 2020 Act, I must sentence you to what is known as detention during His Majesty's pleasure. That means a life sentence in a secure place imposed on a person who commits the offence of murder when himself a child. Section 322 of the 2020 Act requires me to decide the minimum term which you must spend in detention before you can be considered by the parole board for release on licence. it is the parole board which decides whether a person who is in custody is safe to be released. It is important that you and the public understand that a minimum term means just that. It is the shortest period which you must spend in custody before you can be considered for release. But there is no guarantee that you will in fact be released at the end of that period or at any later time. It is only if and when the parole board decides that you are fit to be released, that you will be released, and you will then remain subject to license for the rest of your life. A license requires you to comply with certain conditions or rules. If you offend again, or fail to comply in any other way with the conditions or rules of your license, you may be recalled to continue your life sentence. It is in that way that a life sentence protects the public for the future. In order to decide the appropriate minimum term, I must take into account the seriousness of your offence and the period which you have already spent on remand in custody. When considering the seriousness of your offence, I must have regard to the general principles set out in Schedule 21 to the 2020 Act, and to any sentencing council guidelines which are relevant to your case and are not incompatible with those principles. In this case, I must have regard to the Sentencing Council's guideline on sentencing children and young people, and in particular to sections 1 and 4 of that guideline. I must also bear in mind the factors to be considered when assessing the culpability of a young offender, that is, the responsibility which he bears for his offence, as set out in paragraph 17 of section 14 of the Judicial College publication entitled Child Defendants in the Crown Court, published in June 2025. You accept that you took the knife into school and intended to have it available to use as a weapon, albeit, you said, for protection, having experienced earlier threats and acts of violence. You then used that knife to commit Harvey's murder. That means that paragraph 5A of Schedule 21 to the 2020 Act applies in this case. That paragraph sets out the appropriate starting point for the minimum term for a person aged 15, which, as counsel agree, is 17 years. Deciding the appropriate starting point is the beginning of the process. That starting point is not to be applied in a rigid way without thought. It is to be applied flexibly in order to achieve a just result in the particular case. Having identified it, I must consider whether it is appropriate to adjust it upwards or downwards. I must take account of all relevant aggravating and mitigating factors, meaning all those things which make your offending worse and all those things which count in your favour, in order to reach a sentence which is appropriate in all the circumstances of this case. That sentence will impose the shortest possible minimum term which reflects the seriousness of your offence. When assessing your culpability, I must reflect on and make all appropriate allowances for your developmental age, which may be the same as, or higher or lower than, your actual age, and the level of your maturity. Those principles have been summarised in a number of cases, most recently in a case known as Crown and BGI and CMB 2024 EWCA Crim 1591, and I shall now explain how they apply to you on the facts of this case. A non-exhaustive list of aggravating and mitigating factors is set out at paragraphs 9 and 10 of Schedule 21 to the 2020 Act. I shall take account of all relevant factors, so far as I have not already done so when determining the correct starting point. I first set out all of the aggravating factors in your case. I do not consider that your offence involved a significant degree of planning or premeditation. The prosecution does not suggest that you came to school that morning intending to kill or cause serious injury to Harvey. But that is not to say that you acted on the spur of the moment when you were in the courtyard. On the evidence given by a number of witnesses, which I have already summarised, I am sure that by the time of the science lesson on the 3rd of February, you had decided that, should the need as you saw it arise, you would use your knife on Harvey, a knife which, in your words, you had bought because it was scary. Your history of carrying weapons, including on school grounds, the fact that your offence took place on school premises, and the fact that numerous pupils and teachers were present at the time are all aggravating factors in this case. Turning to mitigating factors, the prosecution case is not that you intended to kill Harvey, but, it says, the severe force which you used, as explained by Dr. Lum, and the fact that you stabbed Harvey twice in his chest indicates the high degree of bodily harm which you intended to cause him. Having regard to all of that evidence and the CCTV footage, I am sure that that is the correct analysis. Whilst your premeditation was not long-standing, it cannot be said that it was lacking altogether. Having come to school with a knife, your behaviour and comments to others from the time of your science class onwards indicate some premeditation at that point. Having considered that evidence and the CCTV footage with care, in the context of your earlier acts of aggression and the available psychiatric evidence, I am also sure that you did not act to any extent in self-defence or in fear of violence. Accepting that he might have made some provocative comment towards you or behaved in a hostile way, it was not, I am satisfied, at a level which indicated to you that Harvey posed any real threat at that time, or which provides any mitigation for what followed. I am also satisfied that, by the point at which you came to stab him, you were the aggressor, and that you acted in hurt and anger at what you considered to be his betrayal of your friendship. I bear in mind your young age at the time of your offence, already reflected in the starting point which I have selected. I must also take account of everything which is known about your mental and emotional development which might have lowered your culpability. The psychiatric evidence received at trial referred to evidence of physical and emotional abuse and neglect in your home life, including a lack of food and, in the psychiatrist's words, excessive physical punishment. Both psychiatrists considered there to be a picture of oppositional behaviour and defiance more obvious in school, and that if you had had a typical level of parenting with appropriate boundaries and discipline, you would have had better emotional regulation, been less likely to have had attachment difficulties, and had improved emotional resilience and self-esteem. The incidents of aggression in the weeks and months prior to your offending, of which the jury also heard evidence, were said to be examples of your difficulties in controlling your emotions, including your anger. The consultant clinical psychologists agreed that your intellectual abilities fell within the very low average range, with particular weaknesses in understanding language and the speed at which you process it. That is thought likely to have resulted from negative early experiences. Nevertheless, Dr. Forster's view was that you did not have any communication issues. He noted that whilst your verbal comprehension and processing speeds were outside normal limits, that was not to an extent which would significantly impair your ability to communicate or comprehend under normal conditions, though in high-pressure situations, your ability to understand and communicate might be more limited. I have also borne in mind the report and observations of the intermediary who helped you throughout your trial and does so again today. Having watched you give evidence over a lengthy period at trial, and acknowledging that you have had the benefit of her assistance, I do not consider that your ability to communicate or understand is reduced to any significant extent. I have had regard to your very difficult family circumstances and upbringing, to your kidney condition and its late diagnosis, the way in which it is managed, and the bullying which you have encountered as a result, and to the separate racist bullying which you have endured. In assessing your culpability, I have taken account of all of those matters and of the way in which you came across at trial. I acknowledge the inherent vulnerability of a person of your age. I acknowledge that adverse childhood experiences and educational difficulties or disruption can affect negatively the development of adult thought processes. As for the offence itself, the incident was short-lived and, until a relatively short time beforehand, unplanned. Nevertheless, you stabbed Harvey forcefully twice in his heart. You were at that time aware of and had recently been advised about the dangers of carrying a knife. I am satisfied that you understood them. Taking full account of everything which I have observed and read, I am also satisfied that your emotional maturity and development at the time of your offence were those of a typical boy of 14, that is below your actual age. In addition to your developmental age and maturity, I bear in mind the evidence of a degree of provocation by Harvey in the context of your knowledge and experience of earlier violent conduct and threats made by certain of his friends, the absence of any prior convictions, the informal role as a carer for your younger siblings, one of whom particularly vulnerable, which you have undertaken from a young age, in the context of your mother's poor mental health and your father's frequent absence from the home, and a degree of remorse. I also bear in mind the mature and positive approach which you have adopted whilst on remand. The Youth Justice team reports that you are known as being well-mannered and well-liked. You have been commended for your good behaviour and twice awarded the title Unit Champion. You enjoy enhanced incentives and earned privileges status, having received 52 positive comments for your engagement, your encouragement of peers to follow instruction, your assistance to staff, and your mature attitude to conflict. You are working in a trusted position, which is said to highlight your character and proactive approach, and have indicated a desire to work towards gaining GCSEs and, ultimately, a professional qualification. I commend you for all of that, and I hope that you will continue to build on the efforts which you have clearly been making towards rehabilitation. taking account of all of the aggravating and mitigating factors to which I have referred, and the need to impose the shortest minimum term which is consistent with your welfare and necessary rehabilitation, I consider that the appropriate minimum term in your case is one of 16 years, from which the time which you have already spent on remand will be deducted, as I shall explain shortly. Your offence of murder was committed with the knife to the possession of which, on school premises, you pleaded guilty. That latter offence formed part of the same sequence of events. In those circumstances, and having regard to the sentence which I have passed for murder and to your offending as a whole, I consider that it would not be just or proportionate to impose any separate penalty for the lesser offence, and I do not do so. That means that your conviction for that offence will not extend the minimum term which I have imposed for murder. For an offender who was 15 at the time of his conviction, Section 366 of the 2020 Act requires the court to make a parenting order in respect of the offender's parent or guardian, if it is satisfied that the order would be desirable in the interests of preventing the offender from committing any further offence. No such order is recommended by the Youth Justice Team, and having regard to the length of the minimum term which I have imposed for murder and your family circumstances, I am not satisfied that such an order is desirable in the interests of preventing your commission of any further offence. Stand up, please, Umar. I shall now summarise the sentence which you will receive and what it means for you. For the murder of Harvey Willgoose, I pass the only sentence which the law allows me to pass for someone of your age. That is detention during His Majesty's pleasure. You will remain in secure custody until the parole board decides that you are suitable to be considered for release. The shortest period of time during which you must remain in custody is 16 years, less the number of days which you have spent on remand. I have been told that that period is agreed to be 259 days. Therefore, the minimum term which I impose in your case is 15 years and 106 days. I remind you that there is no guarantee that you will in fact be released at the end of that period or at any later time, and that if and when you are released, you will remain subject to licence for the rest of your life and may be recalled to continue your life sentence if you reoffend or fail to comply in any other way with the conditions of your licence. As you have been convicted by a jury of the offence of murder, no sentence will be passed on the lesser offence of manslaughter to which you pleaded guilty at an earlier stage. That offence will lie on the file, meaning that it cannot be reopened without the permission of this court or of the Court of Appeal. For your possession of a knife on school premises, you will receive no separate penalty. There are 2 related orders to be made. A victim surcharge will be imposed in the sum of £41 and a collection order made. That surcharge is fixed by law, takes account of your age at the time of your offence, and is used to fund organisations which support victims and witnesses. I order the forfeiture and destruction of the knife. Your legal team will come to see you before you begin your sentence. Please go with the dock officer, Umar.